Well, the jury is now deliberating in the Ashley Benefield trial. We had closing arguments today, and of course, we are going to break everything down. But I think what's important before we get into the actual closing arguments is to really understand the law of self-defense when it comes to Florida. And everybody is familiar with the idea, or if they've heard about this, the stand your ground law, stand your ground statute, stand your ground rule, and that obviously comes into the jury instructions in self-defense. So what we're going to do first, in order to set the stage and be able to use the proper lens when we're looking and analyzing the closing arguments, is to really understand the self-defense law in Florida. So here we go. This is straight out from the jury instructions. I'm going to be reading it and just explaining a little bit, and then we'll go into the closing arguments. Okay, here is how it starts. An issue in this case is whether the defendant acted in self-defense. It is a defense to the crime with which Ashley Benefield is charged if the death of Doug Benefield resulted from the justifiable use of deadly force. So it's a defense to the crime if the force that Ashley Benefield used was justified. All right, well, we're still not clear about what that means. So let's continue. What does deadly force mean? Deadly force means force likely to cause death or great bodily harm. No surprise there. The use of deadly force is justifiable if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting an attempt to commit, let's say, death or a murder upon her or in any dwelling in which she was present. So, if you're using the force, deadly force, to prevent imminent death or great bodily harm, which is about to occur on her, then she is allowed, it's considered justifiable. Now let's continue because it's going to get a little bit more clear as we go on. In deciding, and this is a very important one as well, this is all part of the self-defense jury instruction. In deciding whether the defendant was justified in the use of deadly force, you must judge her by the circumstances by which she was surrounded at the time the force was used. The danger facing the defendant need not have been actual, which means that it doesn't have to be that the danger was an actual danger. Meaning if, let's say, Doug in the back of his mind knew that he was never going to do anything. He never was going to do anything. But that doesn't matter. However, to justify the use of deadly force, the appearance of danger, that's enough. Just the appearance of danger. But the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, the defendant must have actually believed that the danger was real. So based on the circumstances, what would a reasonably cautious person have believed? And again, if you take Ashley Benefield's version of the story, would a reasonable person believe in that situation that they were facing great bodily harm or a danger that is so real? So then yes, then that's all you need. Just the appearance of the danger is enough, and you are justified in using deadly force. Now let's continue to the stand your ground part of the jury instruction. If the defendant was attacked in any place where she had a right to be, so she definitely has a right to be in her house, she had no duty to retreat and had the right to stand her ground and meet force with force, including deadly force, if she reasonably believed that it was necessary to do so to prevent death or great bodily harm to herself. So, does she feel that she's in her house and she has reasonable belief that she is about to either be killed or have great bodily harm done to her, inflicted on herself? If she believes that, then she can go and shoot Doug Benefield in self-defense. It's justifiable. But there's another very important part to this jury instruction, and that is the following. Or, so the first part is if you feel that your life is at risk or great bodily harm, and you're trying to prevent that, and then you're allowed to shoot Doug Benefield in this case. Or to prevent the commission of a forcible felony. to prevent the commission of a forcible felony, you are also allowed to use deadly force. Well, what does that mean? A forcible felony. Well, there's a statute that actually goes through the different types of forcible felony that is applicable in this case, meaning that the defense can argue that Doug was in the commission of these forcible felonies. And they agreed that these are the possibilities: burglary, false imprisonment, or aggravated assault. Okay, so that means the following. When Doug Benefield, according to Ashley Benefield, when he went and slammed the door and said, "You're not going anywhere," even though she told him, "You have to leave now." So number one, she told him, "You have to leave." Now he can really technically be a burglar because she told him to leave. He doesn't have any license to be there. He has no right to be there. And he's forcibly being there. That could be burglary. Again, there's some other elements. We're not going to go into the other elements, but that's the potential. Burglary. Also false imprisonment. She is now imprisoned in her own house. And therefore, then it would be allowed for her to use deadly force, even if she didn't feel that her life is in danger. Even if she didn't feel that way. As long as Doug was in the commission of a forcible felony, which means burglary, false imprisonment, or aggravated assault. Aggravated assault is, for example, I am going to kill you, or I'm going to smash you, or I'm going to break your arms and legs and knees. So that's aggravated assault. So the defense really has two parts that they're going to present here. Number one, she actually felt that her life is in danger. Number two is that even if she didn't feel that her life was in danger, but if he was in the commission of these other felonies, then she's also allowed to use deadly force. Now, there's also an interesting part here about the reputation of Doug Benefield. If you find that the Doug Benefield had a reputation of being a violent and dangerous person, and that his reputation was known to the defendant, you may consider this fact in determining whether the actions of the defendant were those of a reasonable person in dealing with an individual of that reputation. So you see, reputation is important here. What she knew about Doug before is important. It's actually relevant in this case. And then here we go. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether the defendant was justified in the use of deadly force, you should find the defendant not guilty. So if you have a reasonable doubt that maybe she acted in self-defense, then you have to find her not guilty. All right. So that is, I think, an important part of the jury instruction, because really, as we're all sitting here, we all kind of know this comes down to self-defense, whether the jury is going to find that she acted in self-defense or not. So with that out of the way, let's jump into the closing arguments. And I thought, by the way, that both sides, I think, did a very good job on closing today. So let's go to the prosecutor's closing argument. So she started off saying the following. She started off saying that domestic violence, of course, she's going to have to address domestic violence. And that's simple, right? In this case, we're hearing a lot about domestic violence. If she completely ignores it, then that shows that she's not really in tune to the domestic violence part about this. So she has to address it in some way. And she does. She says, look, domestic violence is real. It's just not the case here. This is not a case of domestic violence. And Ashley Benefield was not a victim of domestic violence. What happened here is that she wanted sole custody. She wanted sole custody of that child, and she was going to stop at nothing to do it. And then she says, remember that defense instruction, which, well, she doesn't say this, but we just read that the self-defense instruction. Well, there's two very important words that the prosecution wants the jury to think about when they're thinking about self-defense in this case, and that is reasonable and necessary. Was it reasonable or necessary for Ashley Benefield to use deadly force in this case? And obviously the prosecution is going to argue no, it was not reasonable or necessary. Now, she says, you're right, Doug was no angel. We've heard some things about Doug, even things that he admitted, and he's not an angel. It was unacceptable, but he apologized for it. And this is going to be a theme in the prosecution, that he's working on himself. he may have been an abuser, may have been a person who exhibits power and control over, or exerts power and control over their victims, over their wives, over their partners. But he worked on it. He apologized. There's some text messages showing that he's apologizing for some of the ways that he acted. So you're right. Doug is no angel. He made some mistakes. We all make mistakes, but he's getting past it. And in fact, remember, August 2017 was the last time they lived together. There was no incidents of violence or abuse that we have recorded since August 2017. Now, of course, there's the T-set question, whether that, and then there's also, of course, some of the allegations about what he was doing with Emerson, if he was doing anything. But other than that, we really don't hear about any sort of violence from Ashley's side since August 2017. So it's 3 years. Why would Ashley even think or feel any sort of fear from him? Now, remember also that the South Carolina injunction, that temporary restraining order, was a stipulation. There was no hearings. There was not a finding by the judge that Doug is this monster of a person. It was a stipulation. They both agreed they're just not going to have any contact with each other. And then this is something when the prosecution said something, and as an attorney, this just right away made an impression on me. And if I was the defense attorney, I would have right away wrote down this topic and then come right back to it, probably start off with it in my closing argument. And this is what she said. She said that the conversations with Detective Gillum, remember, there was some testimony from Detective Gillum, and that's when Ashley Benefield was calling him all the time, trying to get Doug Benefield arrested for violating the restraining order that was coming from South Carolina, and then asking him to arrest Doug Benefield in open court, trying to get him arrested, and just her being very, very frustrated with Detective Gillum. And what the prosecution said was the conversations with Detective Gillum. Let's talk about those conversations. But she said that those conversations are the entire crux of this case. Now, when I'm sitting there and I'm listening to this, I'm like, oh boy, that's something that I would write down and come right back to if I was the defense. And I'm going to show you what I would have done. He does address it, but I'm just going to show you what I would have done, maybe a little bit different. So again, you got conversations with Detective Gillum are the entire crux of the case. She tried to use the criminal system to get sole custody. That's what she was trying to do. Those conversations, I will do whatever it takes to keep my baby. Wanting him to get arrested in front of the judge so that she can keep his baby, just so that she can keep her own baby. Then September 2019, she jumps ahead to, he files for divorce and new complaints begin. And then she says something which the defense completely destroyed on his closing argument. She said that on May 4th, and in rebuttal, you don't hear any sort of rebuttal to what the defense argued back to this line of argument that the prosecution started off with. She said on May 4th, 2020, he filed for sole custody. He wanted sole custody May 4th, 2020. We haven't heard that throughout the entire trial. Now, of course, there could be exhibits that were not spoken about during trial that were admitted. And in those exhibits, maybe there's some sort of petition or some sort of filing. But this is what she said. And the defense attorney, when he got up there, he said, that is not in evidence at all. There is no evidence. I'm just jumping ahead to him because I think this is such an important part. Here you have him. If he's filing for sole custody May 4th, 2020, well, wow, that's a real motive now. But we haven't heard it until now. And he got up there and said, there is absolutely no evidence to what she said. There's nothing supporting that Doug Benefield filed on May 4th, 2020 for sole custody. Okay. Then she continues her closing argument. She says, then they go to marriage counseling. And of course, this was all one big sham. She had no intention of reconciling with him at all, as we've seen throughout the testimony. We've seen with Dr. Broder. And a part about Dr. Broder is that she was telling one thing when she was with Doug, and when she was not with Doug, she was telling Dr. Broder she has no intention of reconciling. Okay, we've heard this before. But then sometime in September of 2020, either sometime between 7 or 17 days before she murders Doug, she tells Dr. Broder, I'll take matters into my own hands. Wow. I'll take matters into my own hands. Well, that really sounds like you're up to no good. Now, let's continue. So September 21st, 2020, They have mediation, and they decide they're going to drop everything and go to Maryland. They're dropping the divorce. They're dropping all of their filings. They're dropping everything. They're just going to go to Maryland on September 21st, 2020. Now, as we heard from Stephanie Murphy, actually, there was still something that was going to happen on September 30th, 2020, and that was going to be the release of Dr. Broder's report. Now, we've also heard some conflicting testimony from Ashley Benefield's attorney, who said that no, they're actually not going to drop that injunction hearing at all. Remember, there's also her restraining order that she filed for her petition. The hearing was going to be September 30th. And her attorney testified that she had absolutely no intention of dropping that. And that was the only thing that was going to be heard on September 30th. However, as the prosecution says that no, that was not actually what happened. Stephanie Murphy, the attorney for Doug Benefield, said that no, they were going to drop the injunction, and it was just going to be the hearing about just the release of Dr. Broder's report. Then she goes over again. Let's remember that for 3 years, there was no violence at all since they weren't living together. They were not living together for 3 years. And then she talks about the power and control. Now, remember, we had Ferris, who got up, and he was the expert, the domestic violence expert, and he went through this whole wheel of power and control. And she does a very good job here as a prosecutor. She does a very good job going through the different factors of power and control, that whole wheel, going through each factor and showing how each of those factors are not relevant in this case. So intimidation, how in the world can he be intimidating her when he's in South Carolina? She's living on her own. You don't see any sort of intimidation there. You don't see any emotional abuse. You don't see any isolation. She's with her mother, for crying out loud. She's staying with her mother. That's not isolation. He's not controlling who she's talking to, who she's texting. She can be texting and talking to anybody that she wants. There's no isolation there. What about blaming or minimizing or denying? Nothing. And she even felt comfortable saying that he's not going to move in. So she has no problem with him. She tells him even things that are uncomfortable, that you're not moving in with me. She wasn't scared to tell him that. And then they talk about this idea of this, that at some point there was a neighbor who saw someone in their yard who later they were only able to identify him as someone who's wearing a baseball cap. And then later, when Ashley Benefield played a voicemail of Doug Benefield, then the neighbor said, "Oh yeah, that sounds like the guy who was in my yard looking into your window." He's like, "Come on, give me a break. It's just way too much speculation to say that was even Doug." What about using the children? That was also part of the wheel of power control. He just wanted to see her. He wanted to see his only daughter. He wasn't using any child against Ashley. In fact, prosecution makes a case that Ashley was the one who was using the child against him. And she was controlling all of the visitations. She was controlling everything. She was with him during a lot of the time sharing. What about male privilege? There's no evidence of this. Remember the email that he sent to the realtor when he was looking for a house in the same area of Ashley? He actually said, "I have to ask Ashley first." Well, is that showing you some alpha male that I'm just going to decide where I live and I don't need to ask anybody? He even told the realtor, "I have to check with Ashley first." What about economic abuse? She was already financially independent. What about coercion or threats? Again, nothing for 3 years. What about the domestic victim mentality that you cover for your abuser? Well, there's no evidence of that. In fact, she filed things against him. So, showing how the whole power and control thing, this whole wheel doesn't really have any relevance to what was going on in the relationship between Doug and Ashley. And she did a great job, I think, going through all those different elements and showing how they're all not relevant to Ashley. And then she actually does something which I always think is important to do on closing arguments, and that is to go through some of the important jury instructions. And she does do that. She does that with regard to the second-degree murder. She goes through the jury instructions. She goes through the lesser included manslaughter. And she says that we have to remember that second-degree murder means that you acted with a depraved heart. So, of course, number one, Doug's dead. Number two, Ashley killed him. Okay, those are pretty simple. And one of the most important ones in second-degree murder is the depraved heart. Depraved heart means that there was ill will. There was ill will. So is there any ill will here? She says, yeah, of course there's ill will here. She was trying to keep her child away from her father. She was filing fake complaints. There is definitely ill will between Ashley Benefield and Doug Benefield. And that would therefore give the jury a reason to be able to convict her on second-degree murder. And then again, she comes back to the self-defense theory and says reasonable and necessary. Those are the two words that you have to think about. Was the way that Ashley acted reasonable and necessary when you never had any sort of physical violence ever? There was never any physical violence on Ashley. Now, yes, there was the throwing the gun, which I believe is physical violence. Again, it didn't hit her, but that would still be considered an assault. So but they didn't talk about that too much. And other than that, there has been no physical violence against Ashley. So was it reasonable for her to think that all of a sudden now he's going to be physical with her? And the only thing that we have to go on to say that he actually slapped her was the fact that she testified to that. And then she goes through, she says, look, and she shows up the pictures. She shows the pictures of Ashley Benefield very soon after the murder and saying, where are the injuries? I don't see any injuries here. There is no injuries here. There's no evidence of any injuries. No swelling by her eyes, no red marks, no scratches by her face, nothing. And remember, then she said that her whole act that she did when she was testifying, did you see any tears at all? This is something that some of the other people have posted about it, talked about. There was no tears with those crying. So that shows that she was just putting on an act. It wasn't real. Not one red eye, she said, and there was no snot coming down. And then she said, well, what about the scratch that we saw from the cardboard box? And she says, well, wouldn't you expect there to be a bruise? So there's no bruise there. So we're supposed to believe that this scratch came from this cardboard box that Doug Benefield, slammed the cardboard box into her. What about when I asked her all these questions on the stand about how exactly did it happen? All of a sudden she didn't know. She wasn't able to recount all the details. Was it an open hand or a closed hand? Did he punch you in the face? Did he slap you in the face? Did it do with the back of his hand? She doesn't remember anything. All the parts that I think would something that you'd remember. Again, this is a prosecutor talking to the jury. Then she doesn't remember any of this. All of a sudden, when I get into the details, she doesn't remember. Remember also that John Sance, the neighbor, said he didn't see any sort of injuries on her. And there's been a number of detectives in this case and crime scene techs who also didn't see any sort of injuries on her. And then she starts to talk about the trajectory of the bullets. And remember, this is an important part of the case because of the bullet did not hit him straight on. It hit him in the side, going from side to side, essentially, which would seem to suggest that he was turning away, trying to get away from the situation, not that he was attacking her. When you attack, you go straight on. So she talked about that. And then also, it was interesting because it called Eva Benefield for like 1 second on the stand to say that Doug is right-handed. And then she explained that if you're really fighting, then your right hand would be behind, not the other way. And the way that the bullet came in from the right, going into the right, that would only make sense if you're standing this way because then your left hand is stronger. But if you're right-handed, then you would stand this way. So that was something that she pointed out also. And there's no evidence, she says, there's no evidence that shows that he was actually coming at her at the point. And then also, this is essentially how she finishes her closing argument, is that she never tells her mom what happened. And she's very close with her mother. She's living with her mother. And she never, after that whole traumatic event, doesn't tell her mother anything about what happened. And when she's living with Barbara Russell, that also a mental health professional, she doesn't tell her anything, nothing. And if this was such a traumatic event and that you were acting in self-defense, of course you would talk to somebody about it. But if you're trying to hide the fact that you just murdered someone for no reason, that would be a reason why you wouldn't tell anybody. So that is the prosecution's case. That's why they feel that self-defense is just out. There's no evidence of it. And therefore, you've got to find her guilty on second-degree murder, or at the very least, the lesser included of manslaughter. So then the defense starts his closing argument. Now, again, if this was me, just because the prosecution said that the entire crux of this case is the conversations with Detective Gillum, and he's got some good stuff on Detective Gillum, I would have just started off right away. Ladies and gentlemen, you just heard it from the voice of the prosecutor, that the entire crux of this case is the conversations that she had between Detective Gillum, right? Those conversations, that's the entire, these aren't my words, these are her words. The entire crux of this case. Well, if that's the entire crux of the case, let's talk about Detective Gillum. Now, he doesn't do this. He gets to this a little bit later, but I think that if it was me, I would have started out right away. As soon as I heard that out of her mouth, all my attacks on Detective Gillum would have come right away, saying, this is her words. This is the entire crux of their case. Here we go. Let's talk about Detective Gillum. Now, he's going to talk about it, but let's get to there first. He says that this is a fundamentally flawed prosecution. And he also keeps referring to the fact that they're all taking notes and that you should rely on the notes. And this is a strategy which is very common. And what you want to do is you want to tell the jury that they don't have to believe you. Nobody likes believing lawyers. If you talk about facts, you talk about evidence, you talk about testimony, that people can live with. But if you explain something and the jury's getting the idea that they have to believe you as a lawyer, saying, I don't think that this or that or the other thing, it doesn't register as strongly as you all recall this testimony that was given. I'm just here to remind you of some of the testimony. So that's always going to be a stronger point with the jury than just telling the jury, I don't think that they've proven their case, things like that. All right. So he keeps referring to that. Look at your notes. You're going to see in your notes that you wrote this down, and I'm just going to tell you what probably, if you look back on your notes, you're going to see. So he did start off with that, and he kept coming back to that. And he said that this was a fundamentally flawed prosecution, and there's two of the state witnesses that showed you that. And number one, he talks about Stephanie Murphy. And remember that Stephanie Murphy, and this is something that the prosecution also kind of said in their closing arguments, that really doesn't really make such a big difference between whether the Dr. Broder report was going to be released on September 30th, or she was absolutely going to go ahead with the injunction on September 30th. And they kind of changed it a little bit. It's definitely the way that we heard in the opening and the way that they were presenting their case, it seemed much stronger that their position was going to be that she did not want Dr. Broder's report to be released. She didn't want him, Doug Benefield, to see how she was playing these two different cards, that when he was with her, she was pretending that she wanted to reconcile, and that when she was alone, she was saying she didn't want to reconcile, and that release of the report she didn't want that release. And that was the big motive behind why she killed him. I mean, that was one of their very, very strong motives. And that kind of changed in their closing argument that said, well, she was definitely going to go ahead with that injunction hearing, and that's what's something that she didn't want to go ahead with. So, as you can imagine, the defense attorney completely attacked them, and this is how they're completely changing their theory. And in fact, when Stephanie Murphy was on the stand, he actually asked Stephanie Murphy, do you believe that the reason that Ashley Benefield murdered Doug Benefield was because Dr. Broder's report was going to be released? And she said, absolutely. I have no doubt about it. There's no doubt in her mind. I think he could have said this a little bit stronger, that there was no doubt in this defense attorney's mind, Stephanie Murphy, that the reason that Ashley Benefield killed Doug Benefield was because that report was going to be released on September 30th. And that's also what the prosecution said. But if you look at the emails, and you look at the emails between the judicial assistant for the judge and everybody in that email chain, you will see that there is no mention at all about Dr. Broder's report being released on September 30th. There's just no mention. And remember, Ashley Benefield's attorney testified, and she said Dr. Broder's report was not going to be released on September 30th. It never was going to be released on September 30th. So that's one thing. And then he gets into Detective Gillum. And he says, let's talk about Detective Gillum. Remember that Detective Gillum testified that the reason that he didn't feel that any action should be taken or any arrest should be taken, or the fact that even that he doesn't believe that Doug Benefield violated the restraining order that was in place from South Carolina by sending the TSED, is because the day that the order was signed was November 27th. And that was the same day when he sent the TSED. So how can we say that he did anything wrong? He didn't violate it. He sent it on the same day that the order was signed. But if you look in the emails, you'll see an email from Detective Gillum himself, who contacted Stephanie Murphy's assistant. And he told her in the email that he sees that this this restraining order went into effect November 3rd. And this is Detective Gillum's own words. And he knew that restraining order went into effect November 3rd. Now, let's also remember, Okay, so this is obviously someone who's not keen on telling the truth. Now, also, another part about Detective Gillum is that all of these statements that allegedly were made by Ashley Benefield to Detective Gillum, like, I will do whatever it takes to keep my baby, and I will make you effing arrest him in front of the judge. Those statements that allegedly Ashley Benefield made to Detective Gillum, he didn't put that in any report. And the defense attorney went through how many reports he generally has to author in a year. And he didn't put that in any report until 2.5 years later. And he remembers verbatim what she said to him in the phone call, that he can now put it in a report 2.5 years later. And remember, if it's not in a report, it didn't happen. So this didn't happen officially for 2.5 years. But now all of a sudden, he finds out about a murder. Oh, let's put this in the report now. So this is the same Detective Gillum. So I think that it could have been a lot stronger for the defense attorney to say, this is the prosecution's entire case. They said that the crux of their case are these conversations that, number one, Detective Gillum has been proven to be a liar about this injunction from South Carolina, that very clearly he acknowledged himself in those emails that Doug did violate, yet he never wanted to do anything about it. And number two, all of a sudden he remembers things that were said to him 2.5 years ago and then decides to put it in a report. Yes, I agree. The entire crux of their case is as good and as credible as Detective Gillum. Now, I think they could have done that. He did still make some good points, but I think it could have been just a little bit stronger. Okay, now also remember that Detective Gillum canceled the arrest warrant. There was an arrest warrant that was issued before him by a previous detective who Ashley Benefield initially reported this violation, that Doug violated the restraining order that was put in place in South Carolina. They issued an arrest warrant, and then this Detective Gillum canceled that arrest warrant. He said, you know why this happened? Because this was a good old boys club. They liked Doug. He was the older guy, very persuasive, very charming, and they just liked him, and therefore they just believed him and didn't believe her. And they just liked him, and therefore that's why they ignored all this stuff. And he also talks about how they completely changed their theory of the case, how initially the entire case was about Dr. Broder's report coming out, and now it's turning into, well, she just didn't want to go ahead with the injunction hearing. And then he said both of the theories are not supported. First he said they're ridiculous, and that prompted an objection from the prosecution, and then he had to change it, saying, well, they're both not supported by common sense. Common sense is a jury instruction, so you can argue that. So he said, because the Broder report didn't even have anything negative to say about Ashley, and he found that she had no violent tendencies. That's a great report for Ashley. Now, of course, if the part of the report that she presents one way when she's with Doug and a different way when she's not in front of Doug, and that's what she didn't want to get out, that part he didn't really address. But okay. Now, he continues, the defense attorney, that the reason that the prosecution is saying that she didn't want this report out is because she was nervous about what Doug would do to her or the baby when he found out this information in the report. Now, again, he argued that, remember, Ashley Benefield already filed a number of petitions against Doug Benefield claiming this type of abuse, claiming that he's trying to poison her or trying to, or sexually abusing Emerson. So is she really so nervous about what this stuff is going to say? So much different than the other things, the other facts that she's putting into in these petitions? Remember also that she was searching and Googling how to co-parent and get along with an abusive spouse. Let's talk about the abuse. Then he talks about the abuse. Shooting the gun in the kitchen. That was intimidation. Now, again, of course, this was 3 years ago, but these are some very serious abuse that he did. So he shot a gun in the kitchen. That's something that you remember for the rest of your life, even though it's 3 years later, but you're not going to forget how this person acted. You're not just going to assume that the person just changed. And remember the text messages that she saw from Renee. This is Renee to Doug Benefield saying about how she was kicked on her honeymoon and that he was threatening suicide against her and that he hurts pets. And remember, we heard from Ferris that that's a common common with abusers that they hurt pets. He threw a kitten, throwing kittens downstairs, punching out a dog. And just hearing about how two men were arguing near Ashley Benefield, that caused him to go into such a rage that he wanted to kill them. That's the type of person that we're dealing with, that they're like rats, and he has to rid the world of them. We also know that he violated the South Carolina injunction, that restraining order, and that he was driving from South Carolina to Florida to follow her around. He was obsessed with her. Remember, the realtor, he contacted a realtor to buy a house or rent a house right opposite where Ashley Benefield lived. And then he says, oh, well, I have to ask Ashley. Remember, that came out. He has to ask Ashley. Well, he can't ask Ashley because there's a restraining order. They're not allowed to have any contact. He may be putting that in the email, but he doesn't mean it. So this is just a person who's obsessed and trying to get his way and move near and close to Ashley Benefield. And remember, there was text messages where he acknowledged and apologized for these abusive acts that happened before. And remember that she left this letter to him before she left in August 2017. She left a letter detailing why she's scared of him, why she doesn't want to be with him. That he drives crazy when he's mad and he hits curbs and almost hits trees. That's something that she testified to, so he was allowed to talk about that. Remember Dr. Quintel. Dr. Quintel said that his opinion of Doug was that he was super controlling, that he was jealous, and he was intimidating, a real alpha male. And remember, we had testimony from Dr. Broder and Ferris about go along and get along. That's exactly how these victims act. And they always feel like they're walking on eggshells. They're always looking to appease. So don't when you look at those text messages from September 20th to the 27th, and it looks like everything's happy and they're liking each other's text messages and they're LOLing to each other, that's just to appease the other person. We've heard about why victims act that way. And then he goes about the reasonable doubt instruction. So essentially the argument back that the fact that it's been 3 years is that these are still such significant events, acts of abuse, that she's not just going to forget about it and not just going to think that he got better, that he worked on himself. He went to therapy and he got better. She's not going to do that. It's not just going to happen so quickly. She's always going to remember that he has this side to him and that when you poke the bear enough, you're going to get that type of abuse. So it doesn't matter how many years passed. And then he went and talked about the reasonable doubt instruction, which is, again, something that I always talk about. You got to talk about reasonable doubt. You got to explain it to the jury how incredibly high this burden is of reasonable doubt. And that's what he did. He went through that instruction. And then he said, remember that statement about I'll take matters into my own hands that Ashley Benefield said to Dr. Broder. And we heard the prosecutor talk about this. Prosecutor said, that's what she said to Dr. Broder. I am going to take matters into my own hands, which really sounds terrible. Sounds like she's going to shoot him. That's what it sounds like. But that's not what the testimony was. The testimony was that Dr. Broder said that what he understood, or what Dr. Broder understood from Ashley saying that, was that she meant that she was going to go to the authorities in Maryland. Once they go to Maryland, then she's going to go to the authorities and take care of what she needs to do in Maryland in order to get the proper filings or injunctions, restraining orders, whatever. And that's what she meant. She didn't mean that she's going to go take a gun and shoot him. And then he said that how there's no evidence that Doug filed for sole custody. That was completely fabricated by the prosecution. Remember Justin Warren. That was the lead detective in the case. And of course he mentioned and elicited an objection, but there was no ruling on it. He said Detective Warren was initially the lead investigator in this case. And the state didn't even call him. I called him. So that's an important part that he wanted to get to the jury, to let them know that this is a detective who was investigating. He was the lead investigator, and the state didn't even call him in their case. I called him. And Dr. Vega, Dr. Liu, and Michael Haig, they're talking about the trajectory of the bullets. They said that the bullets went from front to back. So the prosecution's trying to make you believe that this bullet went side to side. It didn't go side to side. He wasn't completely standing sideways. It went somewhat sideways, but it also went front to back. And remember that Justin Warren actually thought initially, something the prosecution actually mentioned in the rebuttal, he actually thought initially that he was shot that he was shot turning away. It was not front to back. That's what Detective Warren, maybe that's why Justin Warren, that's why maybe they didn't call him, because that's not what happened actually in this case. There's no testimony that he was turned around. And then he talks about the shot in the leg. He said the shot in the leg, if we're to believe that he was turning and the bullet went up, that means that Ashley had to have been on the floor shooting up, not standing up. So she had to have been lying on the floor in order for it to get the trajectory of that leg, that the bullet went through the leg going up from the back of his leg up. That means that the trajectory of the bullet was going that way. That was not possible. And Dr. Liu always testifies for the state. She has a career as testifying for the prosecution. And in this case, she's testifying for the defense. And she testified that the abrasions to Doug Benefield's arm is consistent with him lunging towards her. That's consistent. And then also talking about the other trajectory of the bullets, how it's also consistent with what happened in this case, how his legs flew up. And once his legs flew up, that's how the bullet went through his leg in the back. Remember also that Eva testified that Doug was trained in martial arts and how to take a weapon away from somebody. He's trained in this, and Ashley knows that. So when he starts to get into his stance, she can be thinking very reasonably that this is somebody who knows how to disarm somebody else, and he can really inflict some damage on me. And remember, there was photos of swelling and redness of Ashley Benefield's face. Also, remember Barbara Russell. She testified that she saw swelling on Ashley Benefield's face. And then he talks about Ashley herself, her testimony, and what her account was, and everything that happened with him spinning her around and trapping her in her house. And even though she tells him to leave, and then that's why it gets into why it was so important to go through that jury instruction first. It gets into this idea of it's not just the fact that she felt threatened with great bodily harm or death. It's the fact that he now was asked to leave, refused to leave, and now was committing one of 3 forcible felonies, which automatically excuse the use of deadly force. So even if Ashley Benefield didn't even think that he was going to actually kill her, doesn't matter. He was in the commission of a forcible felony. He goes through the different options: burglary, false imprisonment, aggravated assault, and that was it. And now also, remember, there was the final witness for the defense was Amy Carlton, who testified that she was going on a walk and she saw Ashley Benefield run out of that house hysterically. Now, if this was all staged, as the prosecution wants you to believe, this is all staged in a way to get Doug into the house so that she can kill him, so that she can have sole custody of the child, or that Dr. Broder's report won't get released, then why would she run out of the house hysterical? If this is all staged, plan it out. Make sure that the house is exactly how you want it. Don't go running out hysterically the next second. So that's essentially how the defense finished their closing argument. Now, on rebuttal, she did do a pretty good job on rebutting some of the arguments that the defense made. He said it's not crazy that Detective Gillum would remember 2.5 years later the exact statements that were made, because they were such outrageous statements. Again, that doesn't really take care of the problem of why didn't you report it, put in your report. If there's such crazy statements, why did it take you 2.5 years to do it? But she did say, well, there's such crazy statements. He's never heard anything like that in 12 years. So that's why it would stick out in his memory that he can put in his report later. She comes back to the idea that she said, I will take matters into my own hands. That really it means that she's going to kill him, not that she's going to use the authorities in Maryland. Okay, that's just the argument that was already made. So it's not, doesn't really take too much out of the defense. And then she said, well, does it really matter whether it was Dr. Broder's report coming out or whether it was the hearing on the injunction? Either way, she didn't want that hearing to go forward. Now, that kind of acknowledges that you changed your theory in this case. And that doesn't really always look good. So she's saying it doesn't really matter. Why should it really make a difference whether it was because Dr. Broder's report was coming out or because the hearing was going to be on the injunction, the temporary restraining order? Yeah, but once you're doing that, you're kind of taking some of the bite out of your prosecution there. Then she tries to explain how Doug wasn't such a scary guy. He was only 5'9". He was a size small adults men's shirt. I mean, okay, he's 5'9" and 165. He's ripped, and he can certainly do some damage on a little petite woman like Ashley Benefield. Remember Mr. Sant, that sweet old man? He saw no injuries right away. He was right after this shooting. He saw right away, and he didn't see any injuries. Mr. Sant has no reason to lie. He was a sweet old man. So that was a good point that the prosecution made. And she said, well, are we to believe that the reason that Doug Benefield hit Ashley Benefield is because she was tired and wanted to just finish up for the day? That's what we're supposed to believe, that's the reason why, after never laying a hand on her, that's why he decided, oh, you know what? You're too tired. You don't want to continue loading the van, loading the U-Haul and the pod. Smack. Well, truthfully, that's really not the reason. The reason was, remember the testimony was the fact that he was mixing all their stuff together. And she said, hey, I want our stuff separate because we're not living together in Maryland. We're living in separate places. So it really wasn't because she was so tired. That's just how it eventually escalated. And then she kind of plays this idea that Ashley is manipulating everybody. And I understand what she's trying to do. She's trying to say, look, Ashley tried to manipulate the system. She tried to manipulate this doctor and that doctor and these detectives, and she was trying to manipulate everybody. Don't let her manipulate you, the jurors, to think that this was self-defense. So it's a very nice theme. The problem with that theme is that when you say that Ashley was trying to manipulate everybody and all these doctors and all these professionals and Dr. Liu and Ferris and Dr. Quintel, and she just manipulated everybody, that's a stretch to think that all of these professionals are going to be manipulated by this woman, Ashley Benefield. So I understand the idea of the theme, like don't let her manipulate you. Also, don't let yourselves be a victim of Ashley Benefield's manipulation. But if you really think about it, it's really a hard sell to say that she really manipulated all these people. Yes, they did speak to her. They may have taken what she said and used it to analyze whatever they had to. But to say that she's just master manipulator, and that's why you shouldn't let her do that to you, that's going to be a little bit of a harder sell. Again, it's a good, strong point to make to the jury, but they think about it a little bit more to think that Ashley Benefield really manipulated everybody. It's a little bit of a tough sell. So, and then she also said that Ferris is clearly biased by the way that she was answering some of the questions by the prosecution. He was much more forthcoming with the defense. He was the defense's expert, and Ferris is also clearly biased because he really wasn't answering their questions the way that they wanted him to answer the questions, or simple questions. Yeah, it's a decent point. Like, he wasn't answering the questions like so as forthcoming as he was with the defense, but to just like blanketly say that, oh, he's just clearly another victim of this bias and manipulation, it's not the greatest argument either. And then she also tries to play this card, how people can change after 3 years. They weren't together for 3 years. He was an abusive person. Now, again, he has a history of being abusive. It wasn't just that he was abusive at one point in his life and then he was able to get over it. He was abusive with Renee. That was clear from the text messages. And then he was also abusive with Ashley. Now she's trying to play this out as people can change. And that's true. People could change. It's possible for people to change if they really work on themselves. But for someone to actually 100% just believe that, like someone who's especially a victim of his abuse, to just believe that he changed, that's, even though it's been 3 years, it's not such a convincing argument either. Now, another part that she brought out was the fact that they did have a baby together after this whole incident in the kitchen, which, again, she was claiming that he shot a hole in the kitchen to get her to shut up. And then a few months later, you decide that you want to have a baby together. So did that really happen? Why would you want to have a baby with this person? But again, this really goes more into the idea of how victims in domestic violence situations, domestic abuse situations, relationships, how they actually respond and what they do, whether they stay in the relationship, stay out of the relationship. Maybe sometimes they think that a baby will help. There's all types of psychology behind why a person would do this, but she's trying to make it as simple as, well, why would you stay in such a marriage? Why would you want to have a baby with such a person? And then she also says, oh, this fact about the realtor, this argument that the defense made, that they can't have any contact. So how could Doug say in the email, I have to check with Ashley? That's obviously a farce. He doesn't really mean it because he can't even have communication with her. And here the prosecution says, do you really think they weren't having any communication? I'm sure they were having communications. Not really the strongest argument to be made either. All right. And then she says about Detective Warren, the initial first lead investigator in this case, how he originally thought that he was hit in the back. And that's how he charged this. Maybe that's why they didn't call him. And then she says, well, his opinion doesn't really matter. And none of the opinions matter. The only opinion that matters is the jury's opinion, your opinion. And you have all of the facts and the evidence in front of you. So his opinion doesn't really matter. And then she talked about the bias, the fact that on one of the supplemental reports where there was a bias that could have been checked and it wasn't checked. Okay, there's some argument about that, but nothing really too strong there. So that was it for the closing arguments. It was a very interesting trial, I think, to watch. We'll see what the jury comes back with their verdict, but certainly I think there can certainly be an argument, certainly with the forcible felony that Doug could have been committing if you accept Ashley Benefield's testimony. If you completely discredit Ashley Benefield, you'll have a very easy time finding that second-degree murder, finding her guilty of second-degree murder. If you give some more credibility to Ashley Benefield's testimony, that's where this reasonable doubt could creep in about perhaps this being self-defense. So that's it for now. Please, if you haven't yet, subscribe, like, and we will see you next time.